Hey guys, welcome back to another episode of Unwrapped. Today we are going to find out about sentencing. I think there's a big story that's out there whereby we have an Asian individual who got 14 weeks sentence, and we have someone who is non-Asian getting a fine. Yeah, so I think it's something that we hear on the ground that we don't really understand. And we are fortunate today to have Ms. Muntas from IRB law firm, who is here to actually help us better understand. But I think Adi, do you feel it on the ground? I mean, we have a lot of people saying that, hey, how come this guy's sentencing got so high, this one so low? Is it a big issue?
It is. We always feel that if you are from the West, if you have certain skin color, then you get different sort of punishment or different preferred punishment compared to Asians as a whole. Also, the other thing which still bugs my head would be if about the misappropriation of funds. If you are a worker and if you are a leader, so how come some fella who take millions of dollars get away with 2-3 years, then the other one who takes like a few $1,000s get 10-15 years of sentencing, right? But let's deal with the current issues at hand. The victim are both policemen. Both got hurt by a female, but one got a long-term sentence, the other one just walk away with a fine. Now, is it true that it's based on your skin color?
Okay, that's an easy answer. Obviously, the answer is no. The justice system does work. The problem really being sometimes the cases are not reported to a full extent. So sometimes when you read media articles, media reports, it's very hard to decipher why exactly the sentence was given that's so different from a potentially similar case in your view. So a lot of it has got to do with reporting. A lot of it has got to do with information that's been given before the public could make an assessment. But of course, I think recently, actually, the Attorney General Chambers have been a bit more open. Sometimes when the cases are really hot on the ground, they have issued statements to kind of elaborate or to explain why certain sentences were given, which is helpful, I think. I think we are progressing in that manner because society is becoming smarter. They are questioning more, and therefore you see a lot more of dissent or a lot more of questions why apparent similar cases are treated differently.
Okay, so let's talk about the Caucasian lady who scratched the policeman and got hurt. And the other one would be a Mongolian lady who got a jail term right now.
For what?
For kicking the policeman in the groin. Now, tell us the intricate details. How is it being measured?
Okay, so firstly, I have to say I don't have the exact facts of the case. These are not reported judgments. This was not cases where I was present in court. So I'm also basing it based on the media articles. But immediately, two things come to mind. The first, of course, the extent of the injury and hurt. That's a very relevant sentencing consideration. You would see for the Mongolian lady, I think she got 12 weeks and a $3,000 fine. The hurt there apparently is more because the police officer did get a medical cert, issued 2 days of medical cert. And consequently, I think there must have been a bruising or somewhat to the groin area, as opposed to the other case where the Caucasian lady scratched a police officer and I believe kicked the leg of another police officer. You don't see any mention of any medical reports. You don't see any mention of any bruises other than the 2 cm scratch, I think, on the hand. So that's the first distinction, really. When you look at hurt, any type of hurt offences or violent offences, you kind of know on the sentencing consideration is how bad was the injury or how bad is the hurt, and that's something that really defines or changes your sentence. The second really being, of course, both of them face a cumulative number of charges. They had taken into consideration charges. There are other charges. I believe the Mongolian lady had a harassment charge for spewing vulgarities towards police officers. The Caucasian lady shared a few more charges. I think one of it concerns her pushing a taxi driver into the bush. So your charges, all the other charges also makes a difference as to your overall sentence. And without really having the charge or the statement of facts, we call it, which is read out in court, it's quite hard to know what is the aggravating factors in each case. And media articles tend not to dwell into this as well. So that's another factor we look at. What are the other offences that they've been charged with, and are these offences also towards police officers? Are they towards normal persons and all that?
So they are all dissected in court, one by one, all these so-called cases within the parameters of it.
Likely. So what would happen is if they have two similar charges, which is in this case voluntarily causing hurt towards a police officer, the prosecution that brings the case to court would have to guide the court as to what's the sentencing precedent, sentencing benchmarks, and what they are asking for. And the judge hearing that case will also ask the prosecution generally to explain why they are looking for this type of sentences. I noted from both these cases, both the individuals did not seem to be represented. There's no defense lawyer there, I think, because I think one spoke to an interpreter and one addressed the court her own. But generally, if you have a defense counsel also address the court as to whether or not they are agreeable or disagree, obviously, with the prosecution and what they believe the correct sentence should be. So a judge in assessing a case always has to go through that rigor of going through the facts, of asking the prosecution what they're asking for, of what is the normal precedent for this type of cases, and then making a judgment, a decision based on whatever he's asked for or she has asked for.
So everything is measured right down to the core. Immaterial whether you are a local here, Singapore citizen, you are a PR, or you are a migrant worker, or you are a diplomat. Are the measures the same?
I would say for an accused person, it is. For a victim, it's slightly different. A victim, for example, a domestic worker, if you abuse a domestic worker, there are laws that actually makes the punishment higher. So we actually are more protective of the victims, similar to police officers, obviously. So when the victim is a police officer, the punishment tends to be larger than hurting generally a normal individual. But for accused persons, generally the same. We don't treat them differently. And I think to get rid of this sentiment, Adi, that you might have that Caucasians are treated slightly better, we would remember this very famous case of a young boy who vandalized Singapore.
Yes.
And actually there was a
Michael
plea.
Fay.
Yes, Michael Fay. See, we know the name like a household name now. There was a plea from the government not to cane him, right?
Yes.
And we still went ahead. So I would say that I would be very resistant to believing any type of, whether a foreigner, whether they are Asian or expats, Caucasian, Americans, are treated differently. Because time and again as a lawyer, I've been proven that the accused nationality does not really make a difference in the punishment.
So we, the commoners, when we read about an article in the media, we need to reorganize our thoughts. We need to retract and say, okay, what are the other cases that surrounds the same case? Then the aggravation of the pain caused, and all other damages done. So, but these are the things that we do not know. We need to be educated in order to understand this, because whatever that we read in the media are all very funneled up, right? So like, oh, there one white girl and one Asian girl. See, they favor the rest. So hence the reason why we are here with you to understand this better.
Yeah, there has been an increasing, I believe, push towards media to do better. You see it, right? A lot of criticism as to how media chooses to report certain events, and I think that's healthy. I think because the main source of information most public have is the news. The news needs to be more balanced, needs to go a bit more in-depth, especially crime news like this, because it can stir up a lot of emotions. So I think better reporting is one, but of course I do think from the legal end as well, better explanation towards certain judgment, especially oral judgments by judges, might go a long way, because if those get reported, then you will get rid of all these doubts and sentiments we have.
Are these judgments published and open to societies and for us to go to and look at? Is it?
Very rare. Most judgments that are published are either those that has gone on appeal. So I was going to add that if any time any party felt that their punishment was not fair, prosecution could have appealed the Caucasian lady's sentence, for example. And the Mongolian lady earlier, I think she wanted to appeal, but she retracted her appeal. So if there was any feeling that that judge was not partial, you still have another forum to go to when you appeal, which goes towards a higher court, and those judges are more senior, and they actually the one that usually sets the sentencing benchmark. So they know how to, calibrate these cases. But yes, as I was saying, the judgments for the reported judgments are not everyday cases. Most of them involves appeal, or some of them a new area of law. Sometimes a new whole, like for example, when voyeurism became the next big offense, they were prosecuting a whole bunch of voyeurism offenders at the same time. Those judgments sometimes get explained, even though there's no appeal, even though it's not a new kind of area of law, but it's an interesting development of where the sentences are going. So other than that, this normal type of cases, they generally don't get reported, which is why it's much harder to understand.
So is there a reason? I mean, you see, they are the statutes, the deliberations in Parliament. Those are published. Those are accessible. So shouldn't these law case findings be accessible? Or okay, my two questions is: shouldn't it be accessible to the public? And I mean, for reference and examples, do lawyers have access to the judgments?
Okay, so reported judgments, all of us do. There's a website, LawNet, that all of us can search for cases. So most of the important cases that distinguish sentencing benchmarks and precedents, we can all find it. So offhand, if you tell me, Muntas, what's the offense for, having sex with a minor, I can tell you this is the case, this is the benchmark and all that. But if not for that, lawyers also do have our own network. We have friends. So sometimes cases are not reported, but we'll ask our friends, hey, have you done a case like this? And what's the statistical consideration? Has prosecution submitted a submission on sentencing? Can we look at it? So having your own friends in the legal field. But of course, in the public, it's a lot harder. I agree with you, Kevin. So what helps honestly is just having a open and honest discussion. A lot of times on the forums, we see very, I would say, one-sided views lah. But it's important to have discussions for us to understand more. But the reason being why, like why you asked me, why is there no open judgments or open recordings or notes on all the cases, is simply really manpower. I mean, on a daily basis, the courts see hundreds of cases. So I, as a lawyer, I can go to court on one day in the morning, and I can mention, we call it mention, you go to court, 3-4 cases in a day. I could go for 2 plead guilty sessions in a day. That's me, one person as a lawyer. That's what, 4,000 over lawyers in Singapore. So the bulk of the cases do not get reported really because it's going to be very cumbersome to write every single case down and to explain every single judgment down.
Okay, now I thought every judgment has to be documented, so that for reference, for record keeping. But I understand, I mean, the load of work. But if I can just jump back to representation. So we talked about nationality, colours and stuff like that. I think one thing that has been of concern is wealth or background of the victim or the plaintiff. Is it the plaintiff? The accused. All right. So we mentioned that some like these two accused didn't have any representation. So does it really make a difference in terms of having and not having a representation by virtue of being able to argue the case, point out errors that the prosecution might make, or even identifying a better course of action such that I may not get 14 weeks, maybe I can get some. It's all about understanding. So the fact that there's no representation confirm they are already at the losing end.
Okay, so as a judge, he obviously listens to both sides. So even if you are not represented, you are given a chance to address the court. The reality is that without a lawyer representing you, the difficulty really becomes in what you've just said, reducing the charge. A judge doesn't have a power to say, actually, I think your charge is actually slightly lower. As long as the prosecution is able to prove that charge, the judge, basically the role he plays is to sentence. Whereas if you have a defense lawyer, generally, the same offense can lead to many charges. We will be able to kind of figure out which is the least charge, the charge that carries the least punishment. So that's a benefit of having a lawyer, because they negotiate the prosecution even before the case reach the plead guilty. But I would say another benefit of having a defense lawyer, and this has come up many times in my years of practice, is that you are able sometimes to figure out whether this is really a mitigation point. So when you meet a client, something tells you there's more to this, there's a reason for this, and you are able to kind of like get that out and see whether or not it'll make a difference in the case. Whereas as accused persons who come to court personally on their own, they're more emotionally driven. what they think is important may not be important, and what they think is not important and they fail to say may actually be something important. And the judge cannot be penalized on that because it was never told to him. So I guess the reality is that if you don't have a lawyer, you have to really depend on yourself to figure out really what is good to say, what is good not to say. And whereas you have a defense counsel, that job transfers over to them.
Okay.
Yeah.
Okay.
They're able to dribble and dig out the right information and present it correctly, because judge will make his decision based on the fact finding that he has or presented to him.
Correct, absolutely. And another benefit, of course, I mean, I use a very simple example. Let's say an offense is done where they accuse someone of theft, right? And as a lawyer, you know there's a CCTV. You can ask to view the CCTV, right? For you to really determine, did the offense really happen the way prosecution says it says, or was there some room to angle another doubt? Because all you have to prove, actually, as a defense counsel, is there's reasonable doubt. There's doubt as to the prosecution's theory. But whereas as an accused person, you might not have liberty to view the CCTV. You might not know all this. And therefore, a lot of times, actually, what is said, I see in a lot of low-income accused persons, is they believe there's no reason to fight. There's no way I can win this. The government has charged me. I'll just plead guilty, especially if it's a fine. They just want to close it.
So they just surrender.
Yes, they just surrender. We see this quite often. I see clients who come to me and after they find out, oh, this is the amount to charge you, never mind lah, I just plead guilty and pay the fine, because they rather pay it and close the case than pay a lawyer. Because, you know, money is a concern, is an issue, which is why I think Law Society came out the pro bono services to try and balance this out.
Okay.
So it does not matter whether their records are tainted or will be tainted. They just say, yeah, this is enough, just pay and go.
Correct, absolutely. I think that's something everybody in the legal field is alerted to. Of course, prosecution would say no, you wouldn't plead guilty if you're not guilty. But I would say as defense counsel, we see it quite often that people, maybe they're guilty of A, but they've been accused of A++, and they think, okay, you know what, if it's a fine, if I can close the case, I don't have to go up and down the court, I'll just plead guilty. And we actually see it quite often.
I mean, the courts are very intimidating. The moment you enter court, you have this like, oh God, I wish to win. Oh my God, what will happen? People are watching me. So the whole environment is not good for common people. Where are you going? I'm going to the court. And that's the end of it. You know, you are labeled even before you are proven innocent. So hence the reason why the human psyche, or at least for the low income, this is the psyche which they have in mind. And what we need to do is to change all that.
Absolutely. So I think they've done a few. I think there's a public defender office that's coming up in the works. There's Law Society Pro Bono. This is to kind of plug the gap for low-income persons that need representations but don't want to engage a lawyer, don't have the income to engage a lawyer. And a lot of lawyers, including myself, a lot of my colleagues, we actually do a lot of pro bono, low bono work for the same purposes, because we want these people to have access to the tools, to justice, and then yet don't feel like they're going to pay an arm and a leg to get some representation. So that's really where I feel the problem is. A lot of times it's not whether a judge is able to make a sound decision, but whether or not it's presented, whether or not it's explored with prosecution earlier. And that's really something we have to look into, I feel.
I have a question in terms of duration. You know, I think a few weeks ago, an accused who was appealing a case, I think the case was about him abusing his sister's friend or something like that. The case has been ongoing for 5 years. You know, why does it take so long to prosecute some case where it is quite an open-ended approach, or there is some urgency to it? I think that's where people like on the ground, like we say, hey, I know there's a lot of cases, the IO might not have time, but isn't there a process? I mean, 5 years is really long for a sexual offense, you know. So, I mean, there's something we're wondering, why so long? And given that he's able to appeal, he's still out there for 5 years. He can commit more crimes. So I think that's where fairness and the perception of, oh, if you can appeal, you have money, you can go on bail. So I mean, it does give that perception that in the legal fraternity, in the legal framework, if you're better off, you can stay out longer. I mean, what's your experiences on that?
It's a fair point. I mean, when it comes to bail, when an accused person has committed an offense, bail always becomes an immediate issue. A lot of times the bail is just an IC bail. You don't really need to put cash money. But of course, as the crime gets more serious, sexual offense, murder, causing hurt, maid abuse, usually there's a cash surety. And absolutely right, it is the way it is. Low income persons will not be able to put up the bail. And generally, more well-to-do accused persons would be able to go out on bail. But I would say that for those accused persons that are not able to put on bail, the courts are very cognizant of it. So we've attended court a number of times where the judges will remind the defense counsel and prosecution, your client or your accused person is in remand. So please don't sit. Please move the case forward, because you don't want a case where he's serving in remand such a long sentence and then he gets sentenced and it's actually lesser than what he has served, right? Which is almost never happened in Singapore. So we are more cognizant when they are in remand. When they're on bail, I won't say it's on purpose that the cases are set on or have taken very long. I was a prosecutor before as well, in the Ministry of Manpower. I think there are three main reasons. The first being, sometimes the cases is a sequential case. So basically, you prosecute one accused person. After you've convicted that person, you need that person's evidence to go after another person, because that person maybe has not confessed. So in the case that you've just said, where there is an abuse of the friend, I believe a few of them were accused persons.
Oh, okay.
And therefore, they were waiting for each kind of person, so that in case somebody claims trial, they have the person's evidence who has now pleaded guilty on record. So it could be a tactical reason why accused persons are prosecuted later. The second reason, sometimes you're right, I won't deny that I think IOs have a lot of cases, and there has been cases where they've sat on for a while. In law, we call it inordinate delay in prosecution. And the courts have recognized this, where defense counsel argue that these accused persons have carried on their lives per normal, and suddenly, they're caught for an offense 5 years ago and their whole lives now come to a stop. The defense counsel can argue that if prosecution has no reason that they took so long to prosecute, this was an inordinate delay in prosecution, which gives a sentencing discount.
Oh.
But of course, if this person always knew, he was investigator, it's just that he's been out for 5 years and suddenly he's charged, of course he can't raise this defense, because he's always kind of known he's facing a case. And then it becomes contingent on him as well to chase prosecution, to tell him, hey, I need to move on in my life. So a lot of times the accused person don't chase. They're more than happy that they're out on bail and, kind of continuing their life. So very rarely do defense counsels in these cases raise the delay. I mean, it's not fair for them as well. The third reason I can think of why sometimes